Whenever I hear about an interesting case, I always think to myself, if the defendant walked into my office and told me they were hit with this lawsuit, what would be my initial response? And I think sharing that with you, my viewers, gives you a look into the mind of an attorney, which is of interest to a great many people in the public. If that's the sort of thing that interests you, I'm going to ask you to please like, share, subscribe, hit the bell so that you'll see and get notifications when I upload more of these videos. I just finished watching a video from Nick Rekieta on Rekieta Law. I'm going to link below the specific video and his channel. And in the video that I watched, he was discussing that Dominion has just commenced a brand new lawsuit against Mike Lindell and his company, My Pillow. Their allegation is that he committed defamation by blaming issues that related to the results of the election on improprieties that were purportedly committed by Dominion. They're saying that this defamatory action caused them $650 million in damages, and that they're entitled to punitive damages of another $650 million, and accordingly that's a total of $1.3 billion that they are entitled to recover from Mike Lindell. If Mr. Lindell approached me, the first thing I would tell him is that we want to look and see whether or not this is considered a SLAPP suit and whether or not the District of Columbia has anti-SLAPP statutes. What is a SLAPP suit? Well, SLAPP is an acronym for a strategic lawsuit against public participation. That means that sometimes a company will try and quell any discussion of interest to the public because they want to frighten away anyone from speaking ill will of them purely for economic reasons, even though the person is exercising their basic First Amendment rights. Some jurisdictions have something called an anti-slapp action. They've passed something called an anti-slapp act, and some have not. We're going to discuss that in a minute, but the first thing I would look at is, has the District of Columbia passed an anti-slapp act? And indeed, they have. There's a 2010 anti-slapp act that was passed by the District of Columbia, which would govern in this particular case because this case was filed in the United States District Court for the District of Columbia. So let's talk about what a SLAPP suit is and how the Anti-SLAPP Act of 2010 for the District of Columbia may apply in this case. A lawsuit that's filed in retaliation for speaking out on a public issue or controversy. You might be slapped for actions such as posting a blog entry, posting a comment on another person's blog, writing a letter to the editor of a newspaper, testifying before the legislature, reporting official misconduct, or circulating a petition. Often slaps are brought by corporations, developers, or government officials against individuals or community organizations that oppose their actions. Let's talk about what the anti-SLAPP statute in the District of Columbia is designed to protect. There are two categories. Category A is broken into two subsections. A is any written or oral statement made, 1, in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other official proceeding authorized by law, or 2, in a place open to the public or a public forum in connection with an issue of public interest, or B, any other expression or expressive conduct that involves petitioning the government or communicating views to members of the public in connection with an issue of public interest. The Act defines an issue of public interest as an issue related to health or safety, environmental, economic, or community well-being, the district government, a public figure, or a good product or service in the marketplace. The Act specifically excludes private interests such as statements directed primarily toward protecting the speaker's commercial interests rather than toward commenting or sharing information about a matter of public speech from the definition of an issue of public interest. Based on these factors, it seems as if the Anti-SLAPP Act of the District of Columbia is designed to protect people specifically like Mike Lindell in this particular scenario. He, in this scenario, was talking about election and potential election interference or election fraud that may have been committed by Dominion. At the time that he raised this issue, A, it was a matter of public interest because it was something that referred to the community's well-being, so it would fit under B. It would also presumably fit under A because he's issuing written or oral statements that are in connection with an issue that's under review by the judiciary. There were plenty of lawsuits that were ongoing at the time that he made these statements, and accordingly, his statements in this regard clearly seem to be affecting toward the legislative bodies and the various state congresses and how they would act. And there certainly is a lot of grounds here that potentially would imply that the Anti-Slapp Act is specifically designed to protect the type of speech that Mike Lindell committed. In order for him to succeed in this anti-slapp suit, he would have to file a motion within 45 days. The effect of an Anti-Slapp Act is that A, it puts everything on hold, and B, in the event that he is successful, he would succeed in getting the entire action potentially dismissed. Furthermore, he's potentially entitled to attain lawyer fees that he had to, or any reasonable attorney fees that he incurred in having to defend the action. So I think that that would be a very effective way for Mike Lindell to strike back at Dominion and say that you're out of your lane here and that I had every right to make these statements. Now, if I was his counsel, I would further advise him that he should obtain two separate counsels. One for himself individually and another for his company, My Pillow. Well, why would I say you should have two counsels? Not because I'm looking to jack up his legal fees, but the claim that's being made by Dominion is that these statements that he made were hurting him. Now, we know that he's the individual who made the specific statements that are purportedly defamatory. The question is, why are you suing My Pillow? Or why are you suing him individually? Sometimes you can have a person who can be acting in their individual capacity, or they can be acting in their corporate capacity. It's very difficult to be acting at the same time in both capacities. You almost would have to say that he's speaking now about his own personal beliefs and on behalf of My Pillow. That's a very difficult claim for Dominion to make. So you have to ask yourself, well, why are they raising this claim against My Pillow? I mean, it certainly seemed as if he was acting in his individual capacity, and perhaps he was able to come to the spotlight because he's Mike Lindell from My Pillow. At the same time, that doesn't mean he's speaking on behalf or for the betterment of My Pillow. So why are you naming My Pillow here at all? Does he ever say My Pillow says that Dominion committed fraud here? That seems very unlikely. So it would seem, I would think, that My Pillow has a stronger motion here, because they could say, why are you naming us here at all? I mean, we all understand intellectually why they would name My Pillow, because My Pillow presumably has much deeper pockets than Mike Lindell personally, and you always, as an attorney, want to go after the deepest pocket that you could possibly nail, because if you win a lawsuit and the pocket is pretty thin, well, you're not going to actually make any money off of the lawsuit. So you always want to try and get a deep pocket. But that doesn't mean because you'd like to have a deep pocket that they are actually liable or culpable for the actions that caused you whatever damages you allege you sustained. So if you're sitting in the shoes of Dominion and you're facing an anti-slapp motion, and it's coming two separate anti-slapp motions, one from counsel for Mike Lindell individually and another from My Pillow. And this way, even if they can justifiably defend against Mike Lindell individually, they will have a very difficult time defending, I would believe, against My Pillow Inc. Accordingly, you want to separate the defendants, pull them apart, and have the plaintiff, in this case Dominion, just try to justify for the court why it is that they say My Pillow should be on the hook here. Why should they be on the hook? It's very difficult to understand why they were actually named in this lawsuit, other than the fact that you just wanted to have a deep pocket. And that's precisely what anti-slapp statutes are designed to stop. That you should not just start a lawsuit to chill public speech, particularly if My Pillow never said anything. The only one who said anything was Mike Lindell in his individual capacity. Accordingly, it seems as if My Pillow here would have a very strong defense and a very strong motion that it could bring against Dominion. Moreover, I believe that Mike Lindell himself individually has a very strong motion because he has a First Amendment right here. And clearly his statements are being made as to his opinion as to what Dominion did. Opinion can never be defamatory. And when he's saying that Dominion did X, well, you would have to show as that A, he was not expressing his opinion, but expressing his fact, and B, even if he was expressing it as fact, because as Dominion is a public figure, you would have to establish that those statements were being made with malice. Malice does not mean anger or hatred, but that was with a wanton that he made those statements while knowing, or he should have known, that those statements were false. I'm not going to review what Nick Rekieta said in his video about this, because he did a wonderful job breaking down the whole issue of malice in this particular case. So I'm going to recommend that you go over and watch his video. But my point here is that he certainly has valid defenses. The only way that Dominion would be able to overcome this anti-slapp motion would be they would need to establish that they have a high likelihood of success. Well, we know that they're going to struggle with showing a high likelihood of success as against My Pillow Inc., unless there's some statements that I'm not aware of that were made on behalf of the corporation, which seems really unlikely. So we can feel pretty confident that My Pillow will succeed in this motion. And similarly, as Mike Lindell's individual counsel, I would feel very confident that we can show that they don't have a high likelihood of success. Furthermore, their damages, as Nick points out in his video, are very difficult to establish because the public at large now is being inundated by the media with all these claims that there was no fraud, no fraud, no fraud. Well, what is their damage? What did they lose? You want to try and hit him with punitive damages when he's expressing his First Amendment right as to what happened in the election? Good luck with that. Good luck with that. It doesn't seem like that's likely to hold up unless you happen to get a political jury or a political judge which happen to think that they hate Trump, and that since Mike Lindell is a very strong Trump supporter, maybe you could try and find some sort of justification to say that they can overcome these hurdles. It seems as if Dominion has a difficult suit, and if I was his counsel, as I said, I would parse this into two separate issues, and then I would go after them both as My Pillow's counsel and then separately as Mike Lindell's counsel, and I would have two different attorneys doing this, and I think that they would have a pretty strong case here of getting this thing dismissed and getting it tossed out rapidly, and hopefully even recovering attorney's fees. Under the Anti-Slapp Act, the court need not award reasonable attorney's fees, but it is a possibility, and I certainly would shoot for the moon on that as well. Those are my thoughts on this case. I appreciate your time. Thank you very much. Please like, share, subscribe. I'm out.